the largest law enforcement agency in Texas is moving away from arresting people for low-level marijuana offenses. It is the latest development in the chaos that has surrounded prosecution after state lawmakers legalized hemp this year. As of July 10, all Texas Department of Public Safety officers have been instructed not to arrest people with a misdemeanor amount of a suspected drug, generally less than 4 ounces in possession cases, if possible. Instead, they would issue a citation requiring a person to appear in court and face their criminal charges. Those issued with a citation for misdemeanor charges still face the same penalties if convicted, up to a year in jail and a fine of $4,000. Departmental personnel are expected to continue enforcing marijuana-related offenses. The memo states, however, effective immediately, personnel will cite and release for any misdemeanor amount of marijuana. The DPS policy change came about a week before Republican state leaders chastised prosecutors who have dropped marijuana cases or put them on hold because of the new law. The memo by Randall Prince, Deputy Director of Law Enforcement Operations at DPS, was sent out to guide enforcement practices in light of the new hemp bill that passed the Texas legislature, House Bill 1325, and was signed into law last month. Prince clarified that HB 1325 does not decriminalize marijuana, writing, "Because marijuana and hemp come from the same plant, it is difficult to distinguish the two without a laboratory analysis." Nebraska's Attorney General said in an opinion on Thursday the state efforts to legalize medical marijuana would be preempted by federal law and would be therefore unconstitutional. While the opinion concerns specific legislation introduced at the beginning of the year that sought to establish a medical cannabis program, and legal experts said they disagree with this reasoning. The memo could nonetheless have political implications for a separate ballot initiative to legalize medical marijuana. The Attorney General plays a direct role in shaping ballot measures. While the Secretary of State certifies petition signatures, a copy of the initiative is sent to the Attorney General, who will write a ballot question or title that summarizes the purpose of the measure and provide materials that explains the effect of a vote or against the measure. These items will appear on the ballot. The U.S. cannabis industry has seen billions of dollars of acquisitions in recent months, attracting scrutiny from federal trustbusters examining whether planned purchases could quash competition in the emerging marijuana industry. The U.S. Department of Justice's review of the deals, including those involving Chicago-based Cresco Labs, OTC CRLBF, and Arizona-based Harvest Health and Recreation, OTC HRVSF, is weighing on cannabis stocks and triggering concerns whether some of the purchases could unravel. The scrutiny has raised questions about the Justice Department, apparent acknowledgement of an industry that remains illegal under federal law. Cannabis companies, as in any other industry subject to detailed antitrust investigation, are required to list revenue amounts under the so-called NAICS codes. In several cases, the DOJ issued second requests for information from the companies under the Hart-Scott-Rodino Antitrust Improvements Act of 1976. The request can lead to months of additional documentation aimed at determining if deals would violate the law. Cannabis companies are moving forward with acquisitions. Confident deals will close, though delayed. For example, Harvest Health announced March 11 it will acquire multi-state operator Verano Holdings in what was then estimated at an $850 million deal. Harvest subsequently received a second request from the DOJ. Harvest Christine Hersey, Director of Investor Relations, confirmed. Instead of closing the deal in the first half of 2019, as originally predicted March 11, Harvest is now aiming for the end of this year. Raids, arrests, seizures and fines have caught the attention of the California cannabis industry in recent months, as the state's legal marijuana market continues to grapple with financial challenges caused by business lost to state's enormous number of illicit MJ companies. Now, big a hit to the bottom line are licensed marijuana firms taking from illegal operators. Exact numbers are extremely difficult to pin down, but one of the statistics comes from BDS Analytics, which estimated that as of June, a whopping 74% of marijuana purchases in California were made through the underground market. The only other state legal recreational MJ market that has a higher percentage is Massachusetts with 77%, followed by Washington State at 51%, Oregon at 48%, and Colorado at 34%, BDS noted. Nearly 37% of the senior level jobs at cannabis companies are held by women, according to Marijuana Business Daily Survey. Although the number of women holding top spots has fluctuated since 2015, the percentage of women top executives in the cannabis space is still far higher than the national average of 21% for all businesses in the United States, according to the MJ Biz Daily Survey conducted in June. Some industry experts suggest that more competitive markets favor businesses with men in ownership and leadership positions, primarily because of their established access to capital. The money and resources companies need to survive and expand often comes from private capital markets, such as family, investment offices, and venture capital firms, a largely male-dominated industry. The general landscape has changed significantly since MJ Business Daily survey on this topic in 2017. That year, major recreational markets, including Colorado and Washington State, were no longer in their infancy and became highly competitive. This may have been harder on businesses with women executive teams, forcing some companies to close and some executives to exit the industry. Since the previous survey, rec sales launched in California, Massachusetts, and Nevada, while major medical markets such as Maryland, Ohio, and Pennsylvania got off the ground. Many young, quickly growing companies that initially filed key positions in sales, marketing, or operations with whomever they could find, often friends and family members, are now looking to bring in people with more experience and expertise. That's presented a tremendous opportunity for women outside cannabis looking to advance their careers, some of whom may be frustrated with a lack of upward mobility in their current professions. Despite the swings between years, the portion of executive positions held by women in the cannabis industry has consistently outpaced that of businesses in the traditional economy. Because marijuana is illegal in the United States, financially distressed cannabis-related companies are between a rock and a hard place when seeking relief from creditors. It's even difficult for non-plant touching companies to take advantage of federal bankruptcy reorganization, thanks to the U.S. Trustee Program, which is part of the Department of Justice. The Trustee Program recently has stepped up efforts to enforce federal cannabis laws as they relate to personal and business bankruptcy cases, according to the agency. Agency data shows 88 enforcement actions since 2010, with a 53 to 60% of those occurring in 2017 and 2018. More than 50% of those actions were for cases in California, Colorado, and Oregon. There's a glimmer of hope for ancillary cannabis companies thanks to a recent federal appeals court opinion, but only barely. An Iowa state board added chronic pain as a qualifying condition to use medical marijuana, a development that should increase sales in the state's heavily regulated market. Chronic pain generally tends to lead sales for medical conditions in many states. While approving chronic pain, the Iowa Medical CBD Board rejected anxiety disorder and opioid dependence as qualifying conditions and put off a decision on post-traumatic stress disorder, according to the Des Moines Register. The board's recent meeting was the first since Governor Kim Reynolds' May veto of an expression of the medical marijuana program that would have increased THC potency allowances. Qualifying conditions already allowed in Iowa include seizures, Crohn's disease, AIDS, Lou Gehrig's disease, and Parkinson's disease. Thank you for joining Canon News. Be sure to like and subscribe, as well as check out the Investor News channel on Instagram, where you will find daily updates on market news and companies paving the way in cannabis space. I'm your host, Sarah Lee Dobbs. See you next time.